Welcome to India's Legal Legacy, podcast based on real property cases resolved by our specialized team over the years.
Welcome back to the Deep Dive. Today we're opening up the constitutional toolbox. We're looking at what you could call the ultimate legal safety net.
Right.
I mean, if you really want to understand the non-negotiable tools that are designed to prevent the misuse of government power and to protect your liberties, you have to understand the 5 constitutional writs.
That's exactly right. And for anyone, studying law or governance, or honestly, just for anyone who wants to be a well-informed citizen, these writs are just foundational.
So the sources we have today, they really lay it all out.
They do. They're a shortcut to understanding these powerful mechanisms. They let us grasp their function, their history, and I think most importantly, their immediate relevance to your fundamental rights.
And we're not talking about the slow grinding process of, say, civil litigation here.
No, not at all.
We are focused on specific, targeted commands that the highest courts can issue. And I think for our listeners, we should establish the constitutional gravity of this right away.
Well, these writs are essentially the teeth of the judiciary. In India, the high courts use them under Article 226, which gives them significant power.
Okay.
But what's truly unique is the Supreme Court's authority under Article 32, because Article 32 is itself a fundamental right.
The remedy is the right.
The remedy is the right. It gives every citizen the automatic right to approach the highest court in the land directly if their fundamental rights are violated.
Wow.
So that makes these writs absolutely central to constitutional accountability.
That distinction, I mean, the fact that the ability to access the fix is itself a fundamental right, that really speaks volumes, doesn't it?
It says everything about the priority the founders placed on immediate judicial relief.
Okay, let's unpack this. Let's start with the 2 writs that people probably associate most with immediate personal protection and, on the other hand, forcing the government to act.
Let's. And we should begin with the most famous one, the one with the deepest roots in common law tradition. It's the ultimate defender of personal liberty, habeas corpus.
The phrase itself, habeas corpus, it always sounds like the climax of a legal thriller.
It is profound, but its meaning is so beautifully simple. It just means bring the person.
Bring the person.
This writ directly challenges illegal custody or detention.
Mm-hmm.
Historically, it was the earliest offense against, arbitrary arrest by the state.
So if someone is detained, the court issues an order to the detaining authority, the police or whoever,
Yes.
and tells them to physically produce that person in court.
Precisely. And then the detaining party has to prove, to the court's satisfaction, the legal reason for the detention. It's a simple burden of proof, but a very, very high bar.
Okay, but what makes this so powerful?
What's critical here is that the normal rule of locus standi is relaxed.
Locus standi, meaning the person directly affected has to be the one to file the case.
Exactly. Normally, only the injured party can file. But here, that rule is set aside, meaning almost anyone can file this writ on behalf of the person who's been detained, a family member, a friend, a concerned citizen.
Ah, I see. Because if you're detained, you're probably not in a position to file a court petition yourself.
That's the whole point. The mechanism acknowledges that when personal freedom is taken away, the victim often can't speak for themselves.
That just instantly forces transparency.
Yeah.
It forces accountability. But let's talk about the friction here. The state often claims that detention is necessary for, public order or national security.
Of course.
How often does habeas corpus actually win against those kinds of powerful state claims?
Well, even if it doesn't always lead to an immediate release, it creates a vital constitutional check. The court must be satisfied that the process was legal and the grounds are valid. And beyond that, the very existence of this writ, just the possibility that a judge might issue it, acts as a huge deterrent against arbitrary action.
So it keeps the system honest, in a way.
It's why constitutional democracies guard this right so fiercely. It is the ultimate safeguard.
Necessary mechanism, for sure. Okay, so moving from personal liberty to mandated action, let's tackle the next writ, Mandamus.
Mandamus. It translates very simply to we order.
We order.
And this one is aimed squarely at public officials, tribunals, government bodies, anyone performing a public duty.
So if habeas corpus protects you from the state acting against you illegally, Mandamus forces the state to perform its duties for you legally.
That is the perfect way to put it.
Yeah.
Yes. The whole point is to compel an authority to perform a duty that is clearly and legally required of it, especially when they've just refused to act.
Can you give us a slightly higher stakes example?
Yeah.
Something beyond, say, a clerk refusing to issue a license.
Certainly. Think about environmental protection. Let's say a city corporation is legally required by national law to clean up a polluted river that's causing a health crisis.
Okay.
But they just won't do it. They don't allocate the funds. They don't take action. A court could issue a writ of mandamus to compel them to fulfill that specific mandatory public duty.
That's incredibly powerful. But what are the limits? I mean, can I use mandamus to force the government to do something the way I want them to? Like, force them to hire a specific contractor for that cleanup?
And that's the crucial nuance. Our sources are very clear on this. Mandamus can only be issued for a duty that is mandatory.
So, no choice involved.
No choice. It's purely ministerial. Once the conditions are met, you have to do it. It cannot be used to interfere with discretionary powers. The court won't substitute its own policy judgment for the government's.
So it checks inaction on fixed duties, but not the exercise of governmental judgment.
That's right. The duty must be public and legally imposed.
This brings us to a bigger idea. If mandamus is about forcing the government to act properly, it makes you wonder who makes sure the courts themselves don't overstep.
That's a fascinating pivot, because the next pair of writs are designed for exactly that purpose. They regulate the judicial system itself.
Okay, so these are writs of judicial oversight.
Precisely. They ensure lower courts and tribunals stay within their assigned boundaries.
And the sources outline two key tools here, Prohibition and Certiorari. They sound similar, but they operate at totally different times.
They're often called twin pillars, but it all comes down to timing. Let's start with Prohibition. You can think of this as the judicial version of a preemptive stop order.
Okay, so prohibit. What makes a higher court tell a lower court to just stop?
Prohibition is used to stop an action before judgment is even rendered. The higher court issues it when a lower court is acting without jurisdiction or, exceeding its legitimate authority.
So it's a preemptive move. The higher court is basically saying, stop, this isn't your case to begin with.
Exactly. Imagine a special family court starts hearing a corporate tax dispute that's completely outside its authority. The high court could issue a writ of prohibition to that family court, telling it to stop immediately.
So it prevents the mistake from ever happening.
It prevents the judicial mistake, yes.
All right, so if prohibition prevents the mistake, how does that contrast with certiorari, which seems to deal with the aftermath?
Right. So certiorari, which comes from the Latin to be certified or to be informed, is like the full performance review after the fact. If prohibition is the stop sign, certiorari is the order to send up the files for review.
So the higher court checks the completed work of the lower court. But isn't that what the appeals process is for? Why do we need a whole separate writ for this?
That's a great question, and it raises a key constitutional point. An appeal usually looks at the merits of a case. Did the judge get the facts right? Did they apply the law correctly?
Okay.
Certiorari is different. It's generally used when there's a serious error of jurisdiction or a major procedural flaw or a violation of what we call natural justice. It's about the fundamental legality of the process itself.
I see. So it's less about whether the decision was fair on the facts and more about whether the court even had the right to make the decision in the first place?
Precisely. Or if they broke fundamental rules while making it, like, say, not allowing one party to present their side of the story.
And what happens if the higher court finds a problem?
It has two main powers. It can quash the illegal order, just cancel it entirely, make it void. Or, in some cases, it can take the case over itself to make sure justice is done correctly.
That clarifies it perfectly. Prohibition stops the abuse before judgment. And certiorari corrects the abuse after judgment. They're both essential for maintaining the integrity of the judiciary.
And that brings us to the final writ, which steps outside the world of judicial oversight and focuses squarely on integrity in public administration.
This is where it gets really interesting for me. A specific writ that's all about ensuring competence and legitimacy in public service. Let's talk about quo warranto.
Quo warranto. The name itself says it all. It means by what authority.
By what authority?
It's arguably the most democratic of the writs. It allows any concerned citizen to directly challenge the legitimacy of someone holding a public office.
This sounds like the ultimate check against political corruption or nepotism, preventing unqualified people from getting critical jobs.
That is the exact intention. Its function is to question the legality of an individual holding a substantial public office. And the key is that the office must be public, created by law, and permanent.
So I couldn't use it to challenge, say, the CEO of a private company?
No, absolutely not. but you could potentially use it against a cabinet minister or the head of a major government agency.
And what would be the grounds?
Maybe the person doesn't meet the minimum qualifications laid out in the statute. Maybe they were appointed improperly, or they hold another office that creates a conflict of interest.
And the burden of proof is on the person holding the job.
Right. It is. They must prove to the court that they have the legal right and qualification to be there. And this is another case, like habeas corpus, where any concerned citizen can file the petition.
So you don't have to be personally harmed by them.
No, because the illegal occupation of a public office harms everyone. It harms the public trust. And if they can't prove their legal title to the job, the court removes them.
It's a phenomenal tool for upholding institutional credibility.
It's a powerful reminder that public office is not an entitlement. It's a trust given under the law.
All right, let's put this all together. We have habeas corpus, the protector of liberty. We have mandamus, which compels government action. Then the judicial checks, prohibition to stop overreach, and certiorari to correct errors.
And finally, quo warranto,
to ensure the legitimacy of public officials.
And when you look at all five together, what stands out is the genius of their design. They are custom-built legal pressure points. They aren't just abstract laws. They are explicit, actionable remedies.
Right. They ensure that power, whether it's governmental or judicial, can't just operate in a vacuum.
They maintain the structural balance of the Constitution.
And the sources really emphasize that these remedies often bypass all the normal procedural delays. They can provide immediate, sometimes extraordinary, relief.
That speed, that direct access, is why they are called the Constitution's safety net.
And that raises an important question for you, the listener, to think about as we wrap up this deep dive. The people who framed the Constitution, they specifically defined and named these 5 direct legal pathways for citizens to get to the highest courts. They even made the remedy itself a fundamental right.
Yes.
So what does this immediate, explicit, constitutionally guaranteed legal pathway really say about the founders' expectations, about their view of governmental accountability, and maybe their whole philosophy on the citizen's relationship to the state?
That level of foresight, building these emergency levers right into the foundation of the state, it just speaks volumes, doesn't it? It says that the citizen's fundamental rights always have a path to the highest court, and that right is more important than governmental convenience.
Thank you for diving deep with us into these crucial constitutional tools. We hope you feel a little more informed and maybe a little more empowered, knowing about your legal safety net.
If this episode helps simplify legal property matters for you, do share with someone who might benefit. We also love to hear your thoughts, your comments, with your questions or case experiences. Don't forget to follow for more case solutions from India's Legal Legacy team. Until next time, stay legally empowered.